and I'm here on behalf of the Texas Trial Lawyers Association and as an individual lawyer. Let me first begin, Mr. Chairman, by saying that, I'm proud of my profession in many respects, but yet you see things that have occurred, and obviously some of the testimony here today has demonstrated that there are abuses that have occurred within the system. My response to that is not to deny the magnitude of the abuse, not to try to minimize the egregious nature of the conduct, but to try to direct the committee toward the relief that is currently available under the law. And I would like to say something about what happened up in Dallas before it escapes my mind. There were two law firms in Dallas that were engaged in particularly egregious conduct, as I understand it. I do not do much of this kind of work.
There's a lot of money in it.
Well, evidently it must be. The two law firms that I have reference to, I don't want to call their names because I'm not real sure of the names of the firm, but one of them was sued for breach of fiduciary duty by another lawyer representing the clients who were the clients that they had obtained through acts of barratry. The law firm that engaged in the barratry had to disgorge all of the fees that they earned in the litigation that arose out of their acts of barratry, so that they lost all of the profits that they had obtained in that manner. And in addition to that, the other law firm, through acts of the State Bar Association, I believe, and also through litigation, has now their activities have been greatly curtailed. In 2011, Lee and I, sometime back, tried to deal with the situation of frivolous causes of action. And on the books in 2011, Mr. Parsley and I, along with input from the Senate and the House and the Governor's office, worked out a resolution of several different issues that related to perceived abuses. And one of them was, what do we do about frivolous lawsuits? Because there are problems. And how do we handle them? And how do we discourage people? And we passed Rule 91A, and I'm out of time to tell you what we did on it.
I'm going to ask that you tell me what 91A does.
All right, sir. 91A says that if a lawyer files a suit and that there's no basis in law or in fact, and there's no inference that can be drawn from the facts that would warrant the filing of the case, that the judge must conduct a hearing if a motion is filed and award costs and fees, so that the person that is victimized, as some people have talked about here today, they have that remedy available to them under Rule 91A of the Texas Rules of Civil Procedure, which became law as part of, I think, House Bill 274 in 2011. And there are other remedies that are available, but I am out of my time. But there are things that can be done, and I know we had some dialogue at your meeting, and at that meeting I would still like to have more dialogue with the committee on some issues. Thank you very much for your time.
Thank you, Mr. Gunn.
A pleasant and kind meeting.
It was very, very pleasant and very kind.
Very good.
And if I were to say anything other, well, I'd be a fool.